this final video on the PepsiCo case, we're going to look at the calculation of the royalty on which the court levied the royalty withholding tax. Now, we've already talked about the facts in the previous two videos, so very briefly, PepsiCo in the US had a structure by which it sold Pepsi syrups to Schweppes Australia, a subsidiary of Asahi Breweries, a third party, and the Australian authorities said that that price for the syrup should have been split between a royalty for the brand names and the IP, etc., involved in distributing the Pepsi products and Gatorade products in Australia, and the price for the syrup only. That this was not done in order to avoid paying royalty withholding tax, and the Australian authorities levied a deemed royalty withholding tax on the PepsiCo group under the US-Australia tax treaty. Here you can see the claims of the Commissioner. First it was royalty withholding tax, and now we're going to calculate the royalty today, and then there was also a diverted profit tax claim, which we discussed in the previous video. Now I'm going to go pretty highlight over these methods. I think what is interesting for me about this video is the fact that we're looking at in total 7 different methods for calculating the royalty. A lot more detail is in the case itself. Obviously, it's 140 pages, and I'm trying to keep the video to a minimum, so I will go through the summarized text of this very quickly, but I will not give a lot of comments to the methodology. This is more about describing the methodology. And if we look at there were 2 expert witnesses. The first one was Mrs. Wright, and she submitted 4 different methods for calculating this. You can very clearly see from her testimony that she did not think that any royalty was due, and she consistently said that. The judge did not like that and really burned her down for this attitude, but let's get to what she said. She summarized her method, the first method, as follows. Method 1 is based on an analysis of the bottler's business activities, responsibilities, and restrictions per the EBAA. So these were the bottling agreements, to assess 1, the extent to which the payments were made by Sapple to PBS under the EBAs relate to physical assets, IP, or other benefits. 2, the assets provided to and used by SAPL to deliver the service, in particular the extent to which SAPL, this was Schweppes, used physical assets or IP, so which one did it use? The ability of Schweppes to exploit the Pepsi brand. And based on my review, she says, as set out in paragraph 340.43, the tangible assets acquired and used by Sapple or Schweppes are units of concentrate and certain packaging materials. The manufacturing undertaken by Schweppes is limited to adding carbon dioxide, etc., etc. Schweppes' activities generally relate to blending, bottling, packaging, selling, and distribution pursuant to PepsiCo's specification. The IP used by Schweppes are limited to manufacturing instructions, using trademarks to distribute PepsiCo's products, and certain training and assistance. Schweppes cannot use the trademarks for any other purposes, and Schweppes has limited opportunity to exploit the IP for its own benefit other than as a packager and a distributor of the product. So she goes through a functional analysis and says, you know, there's not much you can do with this other than doing what you're being told. Based on the above and on my experience, I also infer the most significant value component of the product is the recipe for the concentrate, as evidenced by the tight restrictions and secrecy imposed by PepsiCo. And the recipe is not provided to Schweppes. So basically, Schweppes is doing very low-risk routine activities here. Additionally, based on publicly available information, Schweppes' activities for PepsiCo are similar to activities it undertakes for other drink manufacturers and for its own products. Selling concentrate alone to a bottler is a common practice in the industry. The EBAs are consistent, these were the bottling agreements, with Coca-Cola's beverage agreements, where the bottler is granted an exclusive royalty-free, again, license to use the trademark solely in connection with the marketing, promotion, distribution, and sale, and where the use of intellectual property is deemed a mere temporary permission, uncoupled with any right or interest, and without payment or any fee for royalty charge. So she says, she does a functional analysis. She says, you know, these guys have the trademark, but they basically need to use it as told. They can't use it for anything else. And by the way, third parties do the same with other third parties, and they don't ask a royalty either. To me, this seems like a perfect analysis in a transfer pricing world. Remember, we are not in a transfer pricing world because we are dealing with unrelated parties. And then the judge goes and cross-examines her. And this is what I'm talking about burning down, because he's not happy with her coming to the conclusion that there is zero royalty. So the judge said, and that's the only thing you take into account in comparing the value of the contribution of the recipe as opposed to the value of the trademark. And she says, In this method, I'm trying to identify what it is that Schweppes, the benefit that Schweppes has, and I'm saying it has limited benefit to use the trademark and it doesn't have the recipe. So it basically has nothing. It's just required to add water and soda, right? For the reasons above, it is my opinion that, she goes on to say, the payments do not relate to the use of the IP that is of any material value to Schweppes as a result of significant restrictions by PepsiCo on the operations. C, there is limited opportunity for the bottler to exploit the IP for itself because A, the intellectual property is tightly controlled, B, the user of the brand does not own the brand, 3, the bottler, Schweppes, is performing routine standard activities, and then in the next point, the portion or extent of the payments that would be for the IP would therefore be de minimis, right? Because you cannot do anything other than what you're being told. And the judge then concludes in a bit of a whining manner. He says, I place little weight on Ms. Wright's method 1, even though in the end he does use it when we've gone through all 7 methods, but he prefers the other expert's method, which is very similar to Mrs. Wright's. And he goes on to say, in my view, as exposed in the cross-examination, there were significant difficulties with this method. And he then describes them. He says, in particular, it had regard to contractual terms that were inconsistent with the instructed assumption that a portion of the payments made by Schweppes under the bottling agreements was for intellectual property. So she did not follow my fiction, and I am not happy with that. That's what he says. Further, it had regard to publicly available agreements and additional bottling agreements that did not provide for payment of a royalty and were inconsistent with the instructed assumptions. So she is blamed for saying, by the way, I see other third parties don't do this either. I think this is a very weird way of dealing with an expert witness. And in tribute to this Ms. Wright, we will put a picture of her and her business here because I really think this treatment for this method was not fair. But let's move on swiftly because we've got a lot of ground to cover. Her method 2 was explained as follows. To allocate the value of payments across the components, I need to analyze the business as a whole and identify the relative contribution of each component to the generation of revenue and profit. So again, she's looking at facts and circumstances, which as transfer pricing specialists, we know is what you're supposed to do. She concluded that she did not have sufficient information to use this method to calculate the amount paid for the IP, as it required detailed information from Schweppes and Schweppes management, and they did not have that. Remember, PepsiCo is on trial here. This method can therefore be put to one side for present purposes. Now, a couple of comments here. First of all, I totally agree that one should make a full business analysis. Second, considering restrictions made by PepsiCo on the use of the trademarks by Schweppes, it is unlikely that the outcome of method 2 would be very different from the outcome of method 1. And thirdly, I wonder, just if you take a step back for a moment, to what extent does the GlaxoSmithKline case in Canada play a role here? Now, remember, in GlaxoSmithKline, Canada bought ranitidine from Glaxo companies in Switzerland and in the UK, I believe. And the question was, why did it have to pay $1,500 per kilo for the ranitidine if it could buy no name brand ranitidine on the market for $200? And the judge's conclusion there was because it could only use the brand name belonging to GSK called Zantac on that ranitidine if it bought the ranitidine from GSK. And the judge says, so there was nothing wrong with the arm's length nature of this price. What is interesting there, and it wasn't part of the case, but there's large parallels between GSK and Pepsi here, is that the court and Canadian authorities did not say, and now we need to split the price of the ranitidine into a part for a deemed royalty to GSK in the UK, and then the rest for ranitidine payments to Switzerland. Now, to be fair, there was a 6% royalty payment to the UK already, but I do think there are still necessary parallels between the GSK case and PepsiCo here worth considering. Let's move on to Mrs. Wright's method 3. And here she's giving the judge what he wants, right? But not in a way that he likes it. So method 3 is a market method based on relief from royalty by benchmarking, the assumed payment of IP to comparable market rates, commonly referred to in the international valuation standards. So now we're getting into the benchmarking arena. I use this method as guidance in researching market comparability rates to determine a reasonable range of royalty rates that could be applicable to Schweppes. The method starts by assuming that a component of the payments represent a royalty payment. And remember, she doesn't agree with this, right? That's why she's saying that it's assuming a royalty payment. Under this method, third-party royalty or license agreements are analyzed. Generally, the net revenue generated by the IP is multiplied by the selected benchmark royalty rate. The selected licensing agreement should therefore reflect the similar risks and characteristics subject to IP. She's looking at the comparability factors. Depending on the terms of the selected comparables, the observed royalty rates may need to be adjusted, so you need to make comparability adjustments. Essentially, the right method 3 involves a search for comparable agreements to find a benchmark for a royalty. Ms. Wright searched a database called royalty range. And then she describes the steps. Step 1, search the database for comparable licensing and royalty agreements in the food and beverage industry. Identify agreements where the licensee produces, manufactures, distributes, and sells food and beverage products. Out of the identified agreements, analyze the fees paid to the licensor for the use of intellectual property and conclude on a typical range of royalty rates. And then finally, step 4, calculate the royalty payment as a royalty rate multiplied by a level of earnings, because that's how you typically determine the royalty. And then she goes on to say, in selecting these agreements, I have excluded agreements where the licensor owns no food or beverage brands, because obviously that we're looking for PepsiCo equivalents. Excluded agreements where manufacturing related intangible assets such as recipes, formulae, or similar know-how were transferred to the licensee, because remember that PepsiCo, the recipe for the syrup was definitely not transferred to the licensee, and one would assume there'd be quite a price tag on transferring that. Selected royalty agreements that calculate the rate as a percentage of net sales were excluded, and I narrowed the search to 8 agreements as my final set of comparables. Based on my research in relation to the royalty agreements, net sales appear to be the most common base for expressing a royalty percentage. The royalty rates range from 1 to 7% of net sales. The medium for the low and higher royalty rates were 2% and 3%, and the average for the low and higher rates 2.3 and 3.5. And I think she throws in the average here because she's a bit given up on the judge, right? However, she goes on to say, as discussed in 434, there are a number of bottling and distribution arrangements that are royalty-free, which appears to be the common practice in this industry. So she says, I found these comparables, but I don't think they are really comparables because they may not all be in the bottling industry. And there are a number of agreements where there is zero rate, but because there are zero rates, they will not be in the databases that we search, right? So you're already dropping a large number of comparables. As such, I have not identified such agreements in the royalty range database, as the licensee does not pay a licensor for the use of intangible assets. Accordingly, I consider the lower end of the royalty rates to be 0%. So she's sticking to her guns. I will give further consideration, says the judge, to right method 3 in the section headed determination of the royalty rates. And that we'll have a look at that at the end of this video when we come to the judge's conclusion.